This case, while no doubt crucial to the participants, is a rather dull tenancy dispute resolved on the basis of English legislation which is never applied in Australia. In short though, T.J. Graham and Sons owned land upon which H.L. Bolton Engineering was a tenant. T.J. Graham wanted the land back so they could build a depot on it, while Bolton Engineering wanted to continue their lease. The relevant legislation, the Landlord and Tenant Act 1954, changed the positions of the parties if the owner of the land intended to occupy the land for the purpose of carrying on a business. T.J. Graham and Sons said that's just exactly what they intended to do. The difficulty for T.J. Graham, however, was that this company ran on a very quiet and informal basis. They only held board meetings once a year, and there were no board minutes to show that they intended to occupy the land for the purpose of running a business. So how could they support their position? The company board left most of the day-to-day running of the company to its managing directors, and these directors, in their dealings with T.J. Graham, had repeatedly indicated their intention to occupy the land for business purposes. Was this enough? Lord Denning for the court found that it was. The words of his judgment have become famous. He said, "A company may in many ways be likened to a human body. It has a brain and nerve centre which controls what it does. It also had hands which hold the tools and act in accordance with directions from the centre. Some of the people in the company are mere servants and agents who are nothing more than hands to do the work, and cannot be said to represent the mind or will. Others are directors and managers who represent the directing mind and will of the company and control what it does. The state of mind of these managers is the state of mind of the company and is treated by the law as such." From this case we learn that although it is impossible for a corporation to literally have a state of mind, the state of mind of its active managers and directors can be imputed to the company, and there is no need for a board meeting or board minute to confirm that state of mind.